Good morning, everybody. My name is Katie Robert, and I work with the Community Health Institute. We want to welcome you this morning to the Tenants' Rights for New Hampshire Families webinar. This webinar is being co-hosted by New Hampshire Legal Assistance, Healthy Families America New Hampshire Home Visiting Program, New Hampshire Department of Health and Human Services Maternal Child Health Program, and Waypoint. This webinar is being recorded and will be posted to the Healthy Families America YouTube channel. A link to the recording will be available after today's live webinar. So this morning we'd like to welcome Kerstin Cornell and Delmy Bonilla. Kerstin is a staff attorney at New Hampshire Legal Assistance, working primarily with the Housing Justice Project. Much of her work is focused on childhood lead poisoning prevention. And prior to working at NHLA, she worked with the DOVE project and Low Income Taxpayer Project at the New Hampshire Bar Association Pro Bono Program. She's a graduate of the UNH School of Law and is committed to a career in legal aid. She lives with her family in Concord. Delmy works at Waypoint with the Healthy Families America Home Visiting Program as a family support specialist. Developing strong relationships with families is the foundation of everything. A former Employment New Hampshire Minority Health Coalition worked on healthy families as a home visitor and Latino community peer educator. She is originally from El Salvador, Central America. So today's webinar objectives. After this webinar, our hope is that participants will be able to explain common legal issues families face related to housing, relate tenant and landlord rights and responsibilities in common scenarios, and identify paths to resources for families to mitigate legal housing issues. A few housekeeping items for the webinar today. Participants will receive a copy of the webinar slides, a link to a brief evaluation, and a link to the webinar recording following the recording this morning. If you're attending the webinar as a group, please share the evaluation link with your colleagues. Speakers will respond to questions at the end of the presentation, but please feel free to chat your questions in at any time. I'd like to go ahead and pass it over to Delmy.
Good morning, everyone. HFA program is a home-based education designed to work with pregnant women and their babies until the child turns 3 years old, then family graduates. This is a long commitment for families, but sometimes families can stop at any time for many reasons. Some because of starting a new job, school, or move to another state. The great thing about this program, it is free, convenient, and voluntary. We can offer support in so many areas. One of them is postpartum health care, baby care, nutrition for both mother and baby, infant brain development, early childhood development, and parent-child interaction. As you can see, we have diversity in our programs of families. Some of them are come from Congo, Africa. Their language are Swahili and Kinyarwanda. And we have Myanmar, formerly called Burma. They speak Rohingya and Burmese language. And also we have Mexico and Puerto Rico Spanish language. And I can say, with all these families that we have, sometimes it's hard to get interpreter, but we always trying to get face-to-face interpreter for their visits. No matter what country you're coming from, as newcomers have to learn how to navigate the U.S. system. Many families face many challenges, some not having family members or friends for the emotional or social support. Or if they have a family or friend, they cannot be there every day for help. Other barriers could be not having transportation, insulation, trauma, low income, not able to read or write in your own language, and not speak English, etc. This brings the topic of families having issues with landlords.
So for this webinar, I just wanted to start very basic to make sure that we covered anything that might be helpful. And so just to start at the very beginning in terms of landlord-tenant law is the issue of a lease and signing a lease. A lease is just basically a legal agreement between the landlord and the tenant. It states the terms that govern the tenant's life pretty much in the apartment or in the home. It gives rights and responsibilities to both parties and essentially creates a relationship between the parties that's legally binding. And there are a lot of things that should be included in a lease. I've up on the slide, things that definitely should be included are the names of all of the tenants, and this includes kids. If a person enters into an agreement while they're pregnant, oftentimes what will happen is they'll just put down new child expected, whatever date. It's really important to have everybody on the lease because a potential reason for eviction would be that there's somebody living in the home who's not authorized to. The lease should also include the length of the agreement. The most common is 1 year. After the expiration of that year, it goes to what's called month to month, which means that you pay a month ahead. You still have rights as a tenant, but you aren't obligated further beyond the 30 days that you've paid unless there's a clause in your lease that changes that. Some landlords will want tenants to sign a new lease at the end of the year. And I always encourage tenants to look carefully to see if those terms match, if they've changed anything. It should include the cost of rent and any late fees and when those late fees become in effect. And it should also state the security deposit and who's responsible to pay the utilities. You basically want to make sure that everything in the lease, everything that has to do with money that needs to be exchanged is included in the lease.
I can mention that in the past, I have called the rental agency asking if the tenant could pay some portion of the rent because they did not have the full amount to pay until the next day. And I was told it was okay, but it was a late fee of $25. And of course, the family did not know about this and they learned that day.
Right. Yeah, and so that's an example of why it's really important to read the lease and just be aware of the possible charges. I will say, however, that it is always good to communicate with the landlord as much as possible. We encourage people to try to, have a human relationship with their landlord, not just a legal relationship. And so, even though the late fee was incurred, it's possible that there was a better relationship formed because that landlord was made aware of the situation. Something else that I would like to note about late fees is that oftentimes rent will be due on the 1st, but there will be a grace period until the 5th. And tenants get this idea that that means that their rent is not due until the 5th. But I think it's important to remember that while no late fee is incurred, it's still considered late. And so if you're using that landlord as a reference in the future, and if the new landlord calls, they very well could say they pay late every month, even if you're not incurring the fee, because it is due on the 1st. So that's just something to be aware of. I hear a lot of people confusing those two things. Other things that may be included in the lease and that I would certainly look for is pets. Whether pets are allowed. There are a lot of variations on this. Sometimes a dog of a certain size is allowed, or only cats, something like that. Who's responsible for repairs? Who's responsible for snow removal? How many cars you can have parking, etc. So the end all be all of this is to say that it's really important to read a lease in its entirety before you sign it, and only sign the lease if you understand it. If you don't understand it, or if your clients don't understand it, ask the landlord so that you can be clear. If the landlord gives pushback about explaining, that's a red flag about renting from that person. The other thing to do is to make sure that you get and keep a copy of it. And this is true of any future lease or any addendum that they ask you to sign, because if something does go wrong and you come to us for some help, the first thing we're going to do is ask you for the lease, because that's the starting point for understanding what your rights are within that relationship.
Now, through my work, I have seen families are signing leases, knowing they are responsible to pay for the rent or for any damage, but really they have not read the whole entire document. And this is difficult because they just don't know. And when a problem comes, that's when they realize, oh, okay, I already signed for this without knowing. I know that some friends or family members trying to help, but it's still, the document is not entirely being read for them.
Yeah, and it's really tough, especially for folks who don't have English as a primary language, or who perhaps don't have high literacy skills. And so something that perhaps your organization could do would be to go through all of the terms of the lease. It's not the landlord's responsibility to read it to them. It's the landlord's responsibility to ask them if they have any questions, or, to ensure that they, to ask if they understand, but they're not obligated to go through each clause, unfortunately, which I know puts a number of folks at a deficit. So it's frustrating. I think that's something that could be really helpful if you're able to do that. So also included in the lease would be information about the security deposit, which is the slide that just came up. And the security deposit is the amount of money that you pay along with first month's rent in order to move into the unit. Under New Hampshire law, security deposit can't exceed the amount of 1 month's rent or $100, whichever is greater. Also, the landlord needs to provide a signed receipt that says where that money will be held. So a security deposit isn't money that you are, or anyone is simply giving to the landlord to use for any purpose. It's money that belongs to the tenant that's supposed to be held in an escrow account that will collect interest. And then if interest has accrued over the course of the time that the tenant is living there, then they're entitled to the return of that interest, as well as the security deposit. So the landlord's required to tell the tenant where that money is being held. And that's something that is really important to do, just so that you know where your money is, because that's your money. So just something to keep track of. And again, if a landlord is giving you a hard time, if you ask for that, it's a red flag, I would say, about renting from that person. The security deposit, the purpose of it is to ensure, or to provide some security for a landlord after the tenant moves out of the apartment, for any damage that may be caused beyond what's considered ordinary wear and tear. There's not much definition of ordinary wear and tear within the law. But the landlord, it's basically their security. It can be used for unpaid rent. So if the tenant moves out and they do have arrears, it can be put toward that. However, it is not meant to be a substitute for paying last month's rent. And so it's important to note that if a tenant does not pay last month's rent, intending to use the security deposit for that reason, but the landlord determines that there's damage done to the apartment, they can take the tenant to small claims court in order to recover the cost of the repairs that they had to do to the unit. So it's risky to think of it as last month's rent. It's really not. The nice thing about New Hampshire is that any deductions that will be taken from the security deposit must be explained to the tenant in writing, and with evidence of the repair. So that would be like invoices for carpet cleaning, or for a painter to come in, or receipts from Home Depot for replacing faucets, something like that. That information should be provided, and the landlord has 30 days from the time the tenancy ends to return the security deposit, or give the tenant the explanation of why the security deposit isn't being returned.
I think this is good information for families that really don't have a clue. the apartments are rented in really bad shape and bad conditions. So this is good information.
Yeah, and that's something that is also a really good point and brings us to the next thing, which is that before you move into a unit, you should always inspect it and always see what is working and what isn't working. Are there tiles coming off of the bathroom, the bathtub wall? You know, are there outlets that aren't covered? Is there peeling, chipping paint? That kind of thing. You want to make sure that you're taking pictures of the condition of the home before you move in, even if everything looks good. Lots of times landlords will want to do a walkthrough with a little check sheet, and will want tenants to initial or sign that everything's in good working condition. It's important that tenants actually determine that it's in good working condition before they sign it. Rather than saying, oh yeah, the stove works, without turning it on. Make sure that the stove works, because once you've signed it, they can blame you for it.
I have witnessed home when a family has moved in and smoke detectors are tripping or not having batteries. Now this is a new concept for newcomers. I personally, you know, coming from my country, we didn't have this. So coming here, you know, I asked, what is this? You know, and other families, sometimes they learn the hard way, you know, when they're cooking and the smoke, you know, the alarm goes off, they're like, what is going on? You know, that's how they learn. There is a smoke detector. But unfortunately, you know, people just don't know. If nobody explained them, you know, what it is, that can save their life. And this can be a problem. So as a family support specialist, I go and I need to explain to them, you know, what it is. And we need to make sure, you know, the working detector is working. And this is what we do. You know, we make sure families are safe in their home, and a lot of education is involved. Our goal is for them to become independent and just to advocate for themselves.
So those are the basics of a lease and getting moved in. I think that the thing that probably scares people the most, or that people have the most experience with, is our evictions from rented properties. And the eviction process is long, and that's both good and bad. It's good because it gives tenants an opportunity to find, hopefully, a new place to move if they do need to move out. It also gives them an opportunity to exercise their rights to have a fair hearing and fair process. It can be difficult because it's complicated. And so I'm hoping that I can shed a little bit of light on that process that people can pass on. So there's two types of residential property. So there's two types of residential property. There's non-restricted property and there's restricted property. Non-restricted property includes single-family homes if the owner owns fewer than 3 at one time, or rental units in an owner-occupied building with no more than 4 units. And restricted property is everything else that's residential. These are distinguished sort of in hopes of, I think, incentivizing and maybe providing some additional protections for landlords who are, you know, small landlords. They just own one home, they're renting out, you know, because for restricted property, there are additional requirements placed on them. Or if an owner lives in the building, there's a recognition by the state of New Hampshire that they may want to have more control over their living environment. And so rights under the eviction statute are slightly different depending on whether it's restricted property or non-restricted property. For all residential property, so this includes the non-restricted property, before a tenant can be evicted, they must be given proper notice. If the reason is for non-payment, they have to be given an opportunity to cure, which means they have to be given an opportunity to pay what they owe in order to stop the eviction. They are allowed to do that 3 times in a 12-month period. So if you've cured 3 times, you don't get a 4th chance, but you have 7 days to actually pay the money from the time you receive the notice. And then notice has to be served properly. If it's non-payment, they have to be given a demand for rent. The demand for rent should only include rent that they owe, not late fees. The law is a little bit shady, not shady. It's not exactly clear on that, but it's NHLA's position that it should only include rent, and that's the argument that we make to the court if a landlord tries to include other fees. So it's important if your clients do get a notice of eviction for non-payment to ensure that the amount that's being demanded on the demand for rent is accurate, especially if they're going to cure. And for restricted property, you have to do all of those things above. And there's also a requirement of what's called good cause. Good cause means a lot of things. So there are some examples on this slide. A couple of things that I want to highlight is that the non-payment of rent is a 7-day notice, as is behavior that adversely affects the health and safety of others. The other notices are 30 days. So a family would get a notice that has to be delivered in hand or left at their most recent place of abode. So usually it's left on the door. It should not be left in a mailbox. It should not be handed to a child. That's not proper service. But so those are 7-day notices. And what that means is that after those 7 days pass, if the family has not moved out or has not cured, then the landlord can move forward with the court process. Aside from that, like I said, it's a 30 days notice. 2 other things that I want to highlight is that if the reason given for the eviction is related to either action of the tenant or inaction, so something that they've done or haven't done, they need to be given notice in writing and an opportunity to change that before they can be evicted for that reason. So if, for instance, family's dog is barking all the time and disrupting other tenants, they need to be given notice that it's a problem before they're evicted for that, so that they have an opportunity to address the problem once they've been made aware of it. The other thing that I want to just make clear is that an eviction notice itself is not it's not court process. So it has not been entered into the court. It's basically a warning that the landlord wants that family out. And so they get the eviction notice. If they continue to reside at the home past when the notice expires, then that's when the court process begins.
Yes, one of my experience was when I saw an eviction notice hanging on the bathroom doorknob, and I asked if they knew about it, and they said no. So, I knew I needed to take an action. The landlord had sent a letter stating the electricity and gas was no longer included in the rent. And of course, nobody was able to read that letter. So, by the time I was there, the eviction was due in 1 week. So that's when I called, the realtor agency and explained the situation. Luckily I was there, able to call, but what if I was not there, that family would be evicted just for something very simple, that they just didn't know.
Right. Yeah.
To read the letter.
Yeah. Which is why the role that you play is so vital and is so beneficial to families, because the law only works if people are aware of it. So, so if the eviction notice expires and the family is still there, then the landlord can start the court process. And so what that means is that they go to court, they show the eviction notice, they show that it's been expired, and they get what's called a landlord-tenant writ, which is basically a summons to court. That writ is then served on the family, and it has on it what's called a return date, which is the most important part of the writ. So the return date is the date by which a tenant has to file in the court an appearance which is how they ask to have a hearing before a judge in order to present their case as to why they shouldn't be evicted. The appearance, if they're not represented, so if they don't have a lawyer, they just check a box saying that they're representing themselves and sign the paper. They can get the appearance form right at the court, or you can help them get it online. We encourage folks to file the appearance the day before the return day because it gives folks the most time to stay in their home to try to work out what their best options are, figure out, you know, if they need to find a new place. So we don't encourage people as soon as they get the writ to run right out and file the appearance, because once the appearance is filed, what that does is it triggers the court to schedule a hearing. And a hearing is typically scheduled within 7 to 10 days. In the larger cities, they're usually 7 days. They're usually the next week. In smaller towns, it takes a little bit longer sometimes. So at the hearing, each party has the opportunity to present their case. In this instance, the tenant would be the defendant, and so they would go second. The landlord would have to prove to the judge why they have the right to evict the tenant, and then the tenant would have the right to explain why they don't think that's true. If a judge finds in favor of the landlord and grants the eviction, that's not the very end. So it's not like that happens and then people have to be out of their home. There are a couple of things that have to happen next. So if the tenant believes that the court made a mistake, then they can appeal the decision, and they have 7 days to file an intent to appeal. And then in order to actually appeal, there's further process that I would encourage people to call us about. And I don't have time to discuss in this webinar, but because there's that appeal period, what's called a writ of possession, which is the document that actually can be used to require somebody to leave their home, issues the 8th day after the judgment. And once the writ of possession has issued, it goes to the sheriff. The sheriff can bring it to the home and require the family to leave. Until that family has a writ of possession, or until one has been issued, the police cannot order the family from the home. The landlord cannot order the family from the home. They cannot lock them out. We see a lot of landlords making threats like that, especially to families who they believe are unfamiliar with the process. So that's something that's really important to know. Further, even if a tenant loses in court, they can ask for what's called a discretionary stay. A discretionary stay is basically a judge saying, okay, you know, like, you're being evicted, but I recognize that for whatever reason, you need more time to be able to move out of this home. And so they'll give the tenant additional time, and it can be up to 90 days. But it's called a discretionary stay because it is completely at the discretion of the judge. It can be 0 days, it can be 90 days, it can be anything in the middle. The best chance that you have for getting a discretionary stay is to present why it is you're not able to move out. And so what we encourage folks to do is, if they are, and we encourage people to be looking for another place to go while this process is ongoing, is to keep a log of everywhere they call, every person they talk to, every step they take to try to find a place to go. If there are barriers to a family finding a place to go, such as having a large family, so they need to find a unit with a lot of bedrooms, or if someone in the home is disabled and that makes it difficult to move, then that would be information to present to the judge in order to have a higher likelihood of getting a discretionary stay and a longer discretionary stay. And then just something also to touch on in terms of eviction is that domestic violence a tenant's experience of domestic violence or activities related to that can be used as a reason to evict that tenant victim. If that tenant provides the landlord with verification that they have a protective order. And so what this means is that You know, sometimes folks will get evictions and it'll say, you know, police presence, like cops coming to the house too many times, or the abuse disturbs the neighbors, or in cases of stalking, you know, there's excessive traffic driving by. If a survivor is able to get a protective order and verify to the landlord that they do have that and that these occurrences have been related to that abuse, it can't be used as a reason to evict them. Secondly, if a court awards exclusive possession of a rented premises to the survivor, the landlord is required to change the locks at the tenant's expense and not give a new key to the excluded tenant. And this is true regardless of if that person is on the lease. So there are a few added protections to try to help survivors of domestic violence. So I want to talk a little bit about non-tenancies. We've been talking about tenancies which are created by a lease. There are types of living arrangements that don't create that same legal relationship. There's a whole list on the slide that you can look at. The most common that we see are boarding or rooming houses primarily, and also single family homes where the occupant doesn't have a lease and it's the primary residence of the owner. And then I guess also the occupants of shared facilities when the owner also lives in the facility and they share a significant portion of that facility, so like a kitchen or dining room or bathroom. So in these circumstances, you don't have all of the same protections that come with a landlord-tenant relationship, and so the eviction process is a little bit different. So those are explained on the slide, and you can take some more time looking at them. But one that I want to highlight again, because we see it a lot, is so boarding or rooming houses. So if a tenant is renting out a single room in a larger building, for the first 90 days that they live there, they don't have a landlord-tenant relationship. After the 90-day point, they do have that relationship and they begin having the same rights as a tenant would in any other tenancy. This gets tricky because what we're seeing is owners of those facilities asking or not forcing people on like the 88th day to go stay in a hotel for the weekend and telling them they can come back, which then you know, restarts the clock before they become a tenant and have those rights. Though I want to note that moving a room within that same building does not break that 90-day count. So that's good. That was a problem that we were having in the past. In terms of eviction from these tenancies for shared facilities, the owner has to give notice to vacate. So they still are required to give the tenant, or not the tenant, you know, the opportunity to have a place, be aware that they have to leave. And then after that notice expires, they can just take possession. So they don't have to go through the court process. This is under a separate statute, it's 540B. And if the person who's living in that space doesn't leave, refuses to leave after the notice expires, they can simply have the police, this is the one time when they can simply have the police come and require that they leave. The other thing to be aware of is rentals is off-season rentals of vacation properties. If you have a written lease that specifies the date when the tenant has to leave because it becomes a vacation property, then it doesn't require court process in order to evict the tenant at that point. However, for the duration of the lease, they do have the same protections as tenants do, which we've just been talking about. So that's evictions. And like I said, it can be a long process, which is both good and bad. And I would encourage people, if they feel like they're in a complicated situation or they don't understand what's going on, to reach out to legal aid. I will talk later about different ways to access legal services, but NHLA's sister organization, the Legal Advice and Referral Center, will give phone advice just by calling in or by sending in an application online to folks who qualify financially, and they can tell them, you know, how to proceed, what to look out for. They can even help them draft something to submit to the court. So jumping to the next topic is talking about the, oh, I'm sorry, Delmy.
Well, yes, I just want to mention again, families having a hard time sometimes to understand the leases. You know, they just don't know either like month-to-month rent or just have to stay the whole year. But the problem comes when the family have decided to move in the middle of the contract, and they go to the landlord and say, where are we living in a month? And then they learn, you know, the landlord said, well, if you leave, then you will be responsible the rest of the month. And again, that's when they learn, you know, that they have to stay. And then, you know, if I'm there, then, you know, they explain the situation. I said, well, you know, and they're right, because you signed the lease and say you're going to stay the whole year. You either stay the whole year, you're trying to find another family that can move in and for the rest of the month.
Mm-hmm. Yeah, and so something that I'll say about that is that it's great. It's always good to communicate with the landlord. If you think that you may have to move, you are responsible for the duration of the lease, but the landlord has a duty to mitigate. So what that means is that they have a responsibility to make their best efforts to find a new tenant for that unit. And then once a new tenant moves in, the family that has vacated is relieved of their duty to pay the rent that they had agreed to in their prior lease. The duty to mitigate includes actions like advertising the apartment. So, you know, you can check and see if it's up on Craigslist. Is it, you know, being made available? In this rental market, we currently in New Hampshire have about a 1.5% vacancy rate. A healthy housing economy has a 4 to 5% vacancy rate. So any apartment that goes on the market should be rented pretty quickly. So if you do have a family who's been in that situation, it's been, you know, more than a month or two and it's still not rented, I would certainly look to see if the landlord is taking the steps that they're required to mitigate, because housing is hard to come by right now, which means that it's getting picked up pretty fast. This is a great time to move into tenants' rights and responsibilities, because I think that we need to help people to understand that while they do have responsibilities, they also have rights. So the responsibilities we've pretty much already talked about. You know, you pay rent on time, comply with the lease provisions, notify the landlord if there's major repairs that are needed, you know, give the notice of moving out, and don't make major changes without landlord approval. So that would be like structural things. It's not like hanging up a poster. But when in doubt, ask your landlord, because if they think it was a major change, they feel they have to undo it or, you know, put it back to the condition that it was in, then they can take that out of the security deposit. Tenants do have a right to safe and sanitary housing. So these rights are covered a couple of ways. So there's a state statute that establishes minimum standards for housing, but then there's also separate municipal codes that establish the same thing. If a city does not have its own code, then it goes by the state statute. The basics of these are that families have a right to not live with pest infestations. So that's, you know, bugs of any kind, like bed bugs, mice, rats, that kind of thing. They have a right to working plumbing system. This includes not having serious leaks. They have the right to a safe electrical system. Their roofs, walls, floors should be intact, and they should have heat and running water. In the state of New Hampshire, a landlord is required to provide heat at the level of 65 degrees in habitable rooms at all times. So I know that that can feel very cold, but that is unfortunately the requirement by law. Something that I want to highlight is that tenants do not specifically have a right to live in a home that's free of lead paint hazards. And I mention this because I hear from families frequently that they think they have this right, and I agree that they should have this right, but that's not currently how it works. You know, there are some provisions, especially with subsidized housing, in terms of being free of chipping, peeling paint, which obviously addresses a lot of the lead paint hazard issues, but it's a really complicated issue. And I think that we're going to be doing a separate webinar just about lead law as it affects housing, because it's a combination of both federal and state law that has changed recently, and that there's some confusion of it seems throughout the state. So that is something that we're hoping to address later.
So yes, talking about safe and sanitary housing, you know, I remember I was told an apartment had mice problems, and several calls were made to the landlord, and the complaint was he never answered. So the family that buying all the products to get rid of the problem, and they said, you know, we felt, you know, we had the courage to say something, and they felt they were ignored. Mm-hmm. And you know, unfortunately, you know, but nothing was done. And the other problem is running water in the bathroom sink. The landlord was notified, and he had gone to see the problem and say, okay, let me come back. And he never come back. And the father said, you know, it's been about 3 months and nothing being fixed. Mm-hmm.
Yeah, and that is why I would encourage all requests to be made in writing, if at all possible. Text messages work, email works, something written on paper works. I know that this is a struggle for families who don't have English as a primary language, so this could potentially be a way that your organization could help families just make sure it's submitted in writing and that they have a copy. Because again, if they call us, which they can do for help, the first thing that we're going to ask for is, did you make that request in writing? Because then you have proof that you made it. I mean, doing it in writing is not the only way to enforce it, but then they have proof and it's easier to move forward. The other thing to do is, if there's a serious problem that's not being addressed, is to contact town or city officials. So if the smoke detectors aren't working, like you were talking about earlier, they move in and they're chirping that there are no batteries. Also, if they are having a significant infestation problem that's not being remedied, they can also call code inspection. And then there are some court processes to try to enforce this as well, which we'll talk about in just a little bit.
And I'm also, you know, I did help, you know, I tried to offer the help, but in this case, this family, you know, he speaks some English, mm-hmm. and he said, no, I will deal with it. Mm-hmm. And what I have heard is that of many families, they say they do not want to complain, mm-hmm. because they feel like landlord will increase the rent. Mm-hmm. And as they already have struggling paying rent, you know, there's something they just don't want to complain, and they just rather leave the problem alone. Yes. Unfortunately.
Yeah, no, I mean, that unfortunately, you know, is a legitimate concern. I will say that we do have a retaliation clause in our statute that prevents a landlord from evicting a tenant because of a report of some sort of something wrong with the apartment. There's a presumption if the eviction is made, or they try to evict the tenant within a certain period of time after the complaint is made, then there's a presumption that it was retaliatory, but it's difficult and it goes through the court process again. So that is definitely a difficult situation.
Okay, so I mean, there is you know, all these issues. So this apartment was rented with a broken glass. Can you go back? And you can see the picture, and I do have permission to talk about this. And it was rented about 8 months ago. You know, with the broken glass right there at the living room, going through the balcony. Now having 2 children, one is like maybe around 6 months, and the other is 18 months. Well, the 18-month boy like to go and stand by that window and look outside. And we have talked about safety issues. And, you know, and again, that has said, you know, I have said to the landlord, but nothing is done. And what he had decided to put is just put the yellow tape just to protect the glass and the child. But again, you know, these are the issues that I see often. And unfortunately, you know, the father did not want to proceed, you know, asking for repairs.
Sure, yeah, and you have to protect your kids, and this is something that comes up with lead paint hazards as well. And what I would just say is that if you're going to take measures, to take self-help measures like that, to do them in such a way that it does not permanently change or potentially damage another part of the home. So putting tape over a broken window is unlike, you know, they're likely to have to replace that window anyway. Taking the step of replacing that window on your own, I wouldn't recommend, because the landlord could say, well, I would have done it differently, and make excuses. So in the same sense of, if you know that you have a lead paint hazard, certainly keep it cleaned up, do that kind of thing. But in terms of taking more permanent steps, you have to be careful, because that could come back in the end to cause problems. So just as tenants have rights, landlords have responsibilities. They're listed here. I think that they're pretty similar to the rights that tenants have, which is just that they have to provide a safe environment. The other thing they have to do is they have to exercise reasonable care in the storage of personal property. So they can do that either by living, and this is for a period of 7 days after the tenant has vacated. That is if the tenant vacates voluntarily, or if they vacate, you know, because of an eviction. So they have to store their possessions and give them access to it for 7 days. They can either leave the possessions in their home, or they can move them to you know, storage unit, but they do have to make them available. After those 7 days, the landlord can dispose of the property, however. So you know, if you do have a client who leaves property behind, they should certainly know that the landlord only has to protect it for a period of time. And as a note for shared facilities, as we were talking about earlier, that obligation is only 3 days. So you can lose your property more quickly. There are things that the landlord cannot do. They're not allowed to circumvent the eviction process. So that means that they're not allowed to try and get around it. Like, they're not allowed to try to convince you to leave or force you to leave without using the judicial process. They also can't interrupt or terminate utility services, deny access to the premise, or deny personal access to personal property, unless, like I was just saying, those 7 or 3 days have passed and they have gained the right to dispose of it. They also can only enter the premises if they have the consent of the tenant. The tenant, however, can't prevent them from making repairs. And so they have to give reasonable notice. Reasonable notice isn't defined under the law. We generally understand it to be 24 hours notice, unless there's a reason why that's not sufficient. However, they don't need prior consent to make emergency repairs. If pipes have exploded, for instance, or if there's a bed bug situation, they don't have to have consent within the first 72 hours after they've been reported. Bed bugs spread very quickly, and so there's a desire to take care of them as soon as possible. So there are also things that the tenant can't do, and I've already covered a little bit of that, which is related to access. They also can't willfully damage property. This is true both before and after receiving an eviction notice. And any property damage, like I said, can be taken out of the security deposit and also can be sued for in small claims court. And there are ways that you can access remedies. As I said a little bit earlier about the court process. So there's a statute, RSA 540A, that provides judicial process to a tenant who is having problems with their landlord not complying with their obligation. That process requires filing a petition under RSA 540A:4. It's a checkbox sheet that you can get either online or at the clerk's office at the circuit courts. It's very simple. I recognize the struggle if you have clients who either have limited literacy or don't have great proficiency in English. But it's something that I think that you could help them with if necessary. It's literally check boxes of what you want the landlord to be responsible for doing. So you submit it at the clerk's office, the judge will rule on it that day, and a hearing will be set within 30 days for both parties to be heard, because under our court system, you have the opportunity for that. And then the order is served on the landlord, and there's no fee for that service if the service is within New Hampshire. So this gets a little bit tricky when landlords live in Massachusetts or in Vermont or in Maine, because service across state lines is not free typically. But these orders can provide quite a few remedies. So they can be an ex parte order, which means that they can require the landlord to take action prior to the hearing. And so, for instance, if the utilities have been turned off, it can require that they restore the utilities immediately, even prior to a hearing. If an ex parte order is issued, the landlord then has a right to ask for an expedited hearing. They would have to make that request in writing to the court, and that hearing would then be held within 5 days of that request. And that would be a similar court hearing. You would present what is wrong, the problem, the need for it to be fixed, and then the judge would rule on it after your landlord had the opportunity to present their perspective. Sometimes money damages are available if the requirements of 540A are breached. The circumstances in which they are complicated and pretty fact specific, and so I can't really get into that now, but that is a possibility. However, I will say that that's not a reason alone. The desire to get money damages alone is not a reason to file a 540A petition, because it's not always going to be awarded. It's not always appropriate. The other remedy of a certain type that tenants have is withholding rent. So if there are significant problems with the tenancy, with the property, tenants in the state of New Hampshire do have the right to withhold rent. The statute that allows them to do so is on the slide, but it's tricky. And if you do it wrong, then you can be evicted for non-payment. So the following, everything below has to be true in order for rent to be withheld. The landlord has to be given written notice of the violation. Again, email, text message, okay, something written, but in writing. The landlord hasn't fixed it within 14 days. It was not caused by you or guests of yours. You have the responsibility to control the actions of your guests, which can be difficult, I realize, but under the law you do. Extreme weather can't have prevented the repairs. There can't be a huge blizzard that has made it so the landlord can't get there to fix whatever went wrong. And you can't refuse to let the landlord in to make the repairs. So if all of those things are true, then you can withhold rent. And by that, I mean you don't give your rent to the landlord. This does not mean that you spend your rent on groceries, unfortunately. It's really difficult because families are in circumstances where money is really tight. And if you have the money and your kids are hungry, it is completely reasonable to want to spend that money. But you have to set it aside because you might have to pay it into court. So if you go to court because of rent withholding, the court may require you to give them the money to hold until they make a determination of how much rent you should not have had to pay. So if you withhold your rent, you go to court, the court would make a determination of the value of the unit in the state of disrepair, and then the amount of rent that was paid and the amount of rent that you would get back would be determined by the court. But if you go and you don't have the money, then the rent withholding fails and it's just, you didn't pay. So that's tricky. Rent withholding is a good tool, but is also hard to navigate and difficult to manage for a lot of folks who are in difficult circumstances. The last thing that we'll talk about is the Fair Housing Act and the right to fair housing. The Fair Housing Act is a federal statute that protects everyone against disparate treatment in housing, both in gaining housing as well as in the experience they have within housing. It protects individuals in protected classes, and those are included on the screen. Given our current cultural climate, want to make it clear that it is not legal to be discriminated against for race or for national origin, religion, any of that. And that if you feel that you're being discriminated against, your clients are being discriminated against because of these things, please call us. Like I said, I'll give more information on how to contact us later, but there are some tools we can use to try to circumvent that from happening to you, but also to prevent it from happening to others. If a landlord is discriminating against one family based on any of these things, it's likely they're doing it to other families as well. And the best thing that we can do is to try to circumvent it as soon as possible. I want to highlight that familial status and disability are also protected classes, which means that a landlord can't refuse to rent to you because you have kids. That would be familial status. And that if you're a person with a disability, the landlord has some further obligations to you in order to make it possible for you to live in a unit. So those are the federal protected classes. New Hampshire has added a few more. One is marital status, also age and sexual orientation. So again, the same requirements apply to those three. It's just that they're protected under state law. So prohibited practices include refusal to sell or rent. If a family who has 3 children applies for a home, and then a family of 2 adults applies for a home, the landlord can't use the fact that there are children as a reason to not rent to the family. There can't be steering. This means that the landlord can't say, oh, I think that you would like this apartment in this other part of the building better. Or, you know, oh, well, this is where all of the folks who have disabilities in this complex live. And you would be amazed at the things that we see. You can be retaliated against for asserting your rights, which again, I know is terrifying to assert your rights sometimes, especially again, in this cultural climate and just generally as a person who does not have the privilege that others do. So the other thing, and this is to do with disabilities that I want to highlight, is that a landlord is required to provide reasonable accommodation or modification for a person with a disability. So this means that a landlord can't make it so that a person is not able to use and enjoy the property in the same way as an able-bodied person could because a person has a disability. This includes things like allowing service animals. In terms of a modification, unfortunately, the tenant typically has to pay for that themselves, but that would be something like a ramp to be able to get into a unit that is accessed by stairs. I will note the reasonableness standard because the requirement is not any. So if putting a ramp on the building is going to you know, cause interference in another way, like people won't be able to access parking spaces or something like that. You know, there could be an objection to that, but that you can make the argument that it is reasonable. And again, if there's fair housing issues, I would really encourage you to talk to us because we'd like to help. So relief, this is really, again, case specific. If it's a reasonable accommodation, if there's a unit that is more appropriate for a person with a disability or perhaps for a person with a larger family, they could get the next available unit or the next accessible unit. In some cases, damages and costs can be awarded. And then other things are that we can try and require that landlords go through training about the fair housing law to understand their requirements under the law, that they required that they submit to monitoring to ensure that they are complying, that kind of thing. So that's just a really brief, I think, overview of fair housing law. And then there's, you know, you can't be discriminated against directly. So that would be, you know, refusal to rent. And then obviously they can't prevent you from being able to use the apartment. I mean, I may have already covered the following. Oh, I will say that you can be evicted for having children or for having another child, whether that be through birth or adoption or foster care. The trick to this, though, is that there is an assumption. So you, however, cannot have too many people in a small unit. So there's a presumption under the fair housing law that 2 people will reside in each habitable room, is how they define it. And a habitable room includes what's typically thought of as a bedroom or a living room or a den, something that's not a kitchen or bathroom, that doesn't have plumbing in it. It's not simply 2 people per bedroom, and the 2 per room is also a guideline. It's not a hard and fast rule. So let's say you have 3 young children, you could make an argument that it's reasonable for them to share 1 room if it's a large room. So that's something to be aware of, especially if you have a large family. There's confusion sometimes about bedroom versus habitable room, and landlords' desire to have fewer people live in an apartment that could accommodate more. So it's something to be aware of. So yeah, accessing legal services, which I keep talking about, that I'm going to tell you. There's 3 organizations in the state of New Hampshire that provide free legal aid. There's a Legal Advice and Referral Center, which is referred to as LARC. There's my organization, New Hampshire Legal Assistance, and there's the Pro Bono program. So the Legal Advice and Referral Center serves as the intake point for both NHLA and Pro Bono for most types of cases. The phone number is there. I am completely aware that there are very long hold times and that it's very difficult and frustrating. Like every other service in the state of New Hampshire, our resources are limited as well. There is the option of submitting an application online, and if a family has this ability, and my understanding is it can be done on a phone. I have not tried to do it on a phone, so I'm hesitant to say that that is 100% true, but that's my understanding. If you submit online, then they will give you a window of time when they will call you back, which means that you don't have to spend forever sitting and waiting for someone to answer the phone. We do have a language access policy. We are required, and we do provide information and services in a person's native language. They just have to identify to us what that language is. We use Language Line for phone calls, and we use Language Bank typically, though not always, for in-person interpreters. So if you call LARC and you speak with somebody and you need interpretation in another language, you simply need to tell whoever you're speaking with on the line, or I believe you can enter that information in the online application, and they will put the person who's calling on hold, call language line, get an interpreter on the phone, and speak with the person in their, they will not speak with them in their native language. They'll provide interpretive services. NHLA and Pro Bono have the same policy. So let me go back. LARC provides phone advice and referrals. So they'll give advice to people on the phone. They can also help with pleadings that a person could submit to the court on their own. They'll help them draft them. And then if it's a type of case that NHLA handles, because we don't practice in all areas of the law, or Pro Bono handles, and that they think is appropriate for referral, they will send it on to us. And then then it would go through case review. What we do is we take the different types of cases, and then weekly a group of attorneys who work in that area of law review them, determine which cases we can take, which we don't think are appropriate for us for whatever reason. And unfortunately, it's often an issue of resources. Again, we have limited resources. We get more requests than we can take for representation. We do also provide advice, and we provide full representation. But the reason I say that we have limited resources is that LARC can be a really good tool for folks who aren't able to get representation. The last organization is the Pro Bono program. The Pro Bono program is through the Bar Association. Again, they have their intake through LARC, and they refer cases to private attorneys who take them on a volunteer basis. And so if a case gets referred to Pro Bono would then determine whether or not it was a case that it would refer, and then it would find a private attorney who would take the case for free. So those are the free legal services. In terms of accessing fee-based legal services, there are a couple of options. There's something called the Modest Means Program. This is a program that was set up for folks who are middle income, have minimal assets, but could perhaps pay a little bit of money to an attorney. So this would be folks who don't qualify for free services, which are under 200% of the poverty line. The Modest Means Program, I believe, goes up to 375% of the poverty line. And the cost per hour depends on the income level of the applicant. There's a $25 application fee at the time of referral that you only have to pay if you qualify. I will say that if a family does not make enough money, if they do not make above what would price them out of our services, they don't qualify for the program. So it's really for middle income folks, and that can be really frustrating, I know. But the fee that the attorneys would charge would be between typically $80 and $125 per hour. And again, that would depend on the income, the household income. Typically, the attorneys do require a retainer, and that would be usually between $800 and $1,500. And then lastly is the lawyer referral service. And this is a referral to attorneys who charge their full fee. So it will direct a potential client to an attorney in the practice area that's appropriate. There's no cost for the referral, but attorneys charge their full fee. People who call in will be given 3 referrals, but only 1 at a time. I do want to highlight that some types of cases are taken on a contingency basis. So this would be like personal injury cases where money could be recovered. And so a client wouldn't have to pay unless they win, and then they would give a portion of their recovery to the attorney. There's also something called unbundled services that's allowed in New Hampshire that's not allowed everywhere. And this allows attorneys to provide clients with limited services. So if you are needing assistance with a divorce and you just want help filling out paperwork or some information about navigating the process, you can get some unbundled services, and those typically cost much less, and it's a flat fee that you work out ahead of time. And so if you're not able to access any of the other resources I just said, if you call the lawyer referral service and say that you're seeking some unbundled services, they may be able to point you towards an attorney who would be able to do that, and you could negotiate a fee for that. Last couple of slides are just, the last slide for resources is just places you can go online to find further information, and the number for modest means. Something else to keep in mind is local welfare agencies. I know that they can be difficult to navigate. NHLA has a program, or a program's not the right word, but every day there is either an attorney or a paralegal who's assigned to help individuals who are having a hard time navigating local welfare that day. So if you try to apply for assistance through local welfare and you're either denied the opportunity to apply, or if you're given a denial that you believe is inaccurate, that you should have not been given that denial, then you can call NHLA. That would be a direct call to NHLA, not through LARC, and there will be somebody to assist you on an emergency basis. And so that's something to keep in mind. That's a service that we provide and try to help people with. The first thing you'll be asked when you call, if it is a situation where you've been denied, is for a written notice of decision. So make sure that you get a copy of that. Just a little tangent.
Well, okay, so I have mentioned all the family issues, and maybe you might think, well, for us might be some easy problems to solve, but working in this field, I have seen is not for them. And unfortunately, there is not a lot of places that I know families can go to. I know Congolese, I have asked, and they say they really don't have a place where to go. They might have to go just to a church, where they attend and ask for some help there, or maybe a friend or family they might know that has been living here longer than they are. And Rohingyas, there is a Rohingya society in Nashua where they have the mosque and people can go there. Actually, only males can go to the mosque, but they can go and talk to them and get some help. And also, I have attended National Navigators Coffee and Conversation at United Way, and sometimes they have it at the library. And they just go and meet and talk about any issue they have. And so that way they create like a networking for themselves and help them, and us, working, having HFA program in their life, we can help once the problem comes in. And I guess that's the only resources that I know that people can approach.
Thank you, Kerstin and Delmy, for presenting. Just to summarize, some of the key takeaways that we have today are that families experience legal housing challenges of all kinds, especially New American and other non-English speaking families. Family support specialists can help increase the understanding by families of tenant and landlord rights, and that there are many legal remedies for housing issues, and those go from self-help remedies to free legal services to low-cost legal services. So at this point, I'm going to go ahead and open it up for question and answer for a few moments. I see that we have one in the chat box already, but I'm going to set it so that folks can unmute themselves if you would like to go ahead and ask a question. So I'll go ahead and start with Kristin's question in the chat box. And that question is it law that landlords have to provide an interpreter for families who do not speak English?
So that's complicated. It depends on, so if it's a private landlord and there's no subsidy, then typically no. There are some circumstances in subsidized housing units where a landlord would be required to, but when that requirement comes into play is complicated. It has to do with the number of folks who live in that unit who speak that particular language. So I guess the answer is not usually, but sometimes, maybe.
Other questions? Please feel free to chat them in, or you can unmute yourself and ask the question. Okay, another question here. For clients that are being evicted due to activities related to domestic violence, substance abuse, stalking, are they able to file a 540 petition, or should we refer to LARC?
So I would say refer to LARC because that's a really complicated question. I'm not sure how to answer in this forum. If they qualify for relief under 540, like I was just talking about, then they certainly can file a 540 petition. But I would say that, you know, in complicated situations, it's always a good idea to reach out to LARC and speak with an attorney. It's hard to say with, you know, cases are so specific in those senses.
Just gonna give a moment in case anyone else is typing a question. Or you can also unmute yourselves if you'd like. Okay. All right, well, if there are no other questions, we're going to go ahead and close the webinar today. Thank you all for participating and being part of this learning opportunity. Once again, we will be sending out a webinar recording link to all the registered participants. We'll also be sending out an evaluation link, and we will have a PDF copy of the slides for your reference. Thank you for your time and your participation this morning, and hope you all have a wonderful day.